You probably want to know, how long is my divorce going to take in Alabama? It's really going to depend on where you are. There are some counties where our office practices that you can get divorced start to finish in 6 months. There are other places where it literally could take 2 years or more. It is really going to be determined by what judge you have, what court system we're in, and what county. It can be determined by the complexity of your divorce. If you and your spouse can reach an agreement on everything in your divorce, you can be divorced in as quickly as 30 days in Alabama. We call those a non-contested divorce. And in those, we file your paperwork, the judge waits 30 days to enter a final decree, and you're divorced. Other places, you're going to fight it out. There's going to be discovery. There's going to be depositions. There's going to be pendency hearings. There's going to be a final hearing. There's going to be a long process that it could take 2 years or more to get divorced. Most of the time in Alabama, it's going to take you probably 9 to 15 months or so to get divorced, depending on where you live and the complexity of your case. What are the legal steps that are going to happen in your divorce? We always start a divorce by filing what's called a complaint or a petition for divorce. That complaint or petition is going to lay out who you are, how the court has jurisdiction over you, kind of a little nutshell version of your situation, and what you're asking the court to do. Then you've got to get the other side served. After they're served, in Alabama, they have 30 days to file an answer. Once in a blue moon, people may not file an answer, and if they don't, after their 30 days is run out with no answer being filed, we can ask the court to give you what's called a default judgment, which simply means you get everything you're asking for because they didn't answer in the time they were required to by law. So if that happens, we can get that done. Typically, people are going to take it seriously and will at least file some kind of minimal answer. After they answer, then the court typically within 30 days or so is going to schedule what is called a pendente lit. That's a fancy Latin word that means while the case is pending, a temporary hearing where issues that can't wait to your final hearing a year from now, things we got to deal with right now, like who's going to have children temporarily, who's going to pay the bills in your home, who's going to make sure that the kids get to school. All these things that can't wait for a year for your divorce to get finalized to be determined are going to happen at that temporary hearing. Some divorces will get totally resolved at the temporary hearing. If you don't own real estate, if you don't have debts to worry about, your personal property's already divided, and all we're dealing with is the custody of the children, and we reach an agreement or we have a hearing and the court determines what they're going to do on a pendente lit basis, at that temporary hearing, that may work out to be the final order in your case eventually. So it's possible that your divorce is going to include that temporary hearing, and then after that's over, things rock along. We do discovery, which is where both sides will work to build their case. We're going to send questions back and forth to the other side that they have to answer under oath. Maybe they have to request documents from the other side. Maybe we do what we call requests for admissions, where they have to admit or deny certain things that we'll then use later on. And eventually there's going to be a trial. Now, a trial seems really scary because you've probably seen it on television, you've watched it on your favorite Netflix show, and you wonder, oh my gosh, are they going to beat me up on cross-examination? Well, they're probably going to try to, but the way we get information to a judge in your case is through your answers to our questions. And so the good thing is, you're probably stressed about going to court. It's easy for me to say, don't be stressed, because I'm in court every day, but I would tell you, don't be stressed. If you go in, you tell the truth, you're brief with your answers, your lawyer's going to ask you the questions that are needed to elicit all the information for the judge to hear what he or she needs to make a decision in your case. So we work through that process, and eventually all the trial's going to be over. Both sides have presented all the evidence and testimony they want to the court. The judge is going to, what we call, take it under advisement, which means that she's going to think about what she's heard, look over the law, review all the exhibits, and make a decision, put out a written order, and then you're divorced. A divorce can be a very document-heavy process, and you may wonder, okay, I'm going to get divorced. I've got to start preparing things for it. What do I need to get together? Here's what we need. We need pay stubs. We need bank statements. If you and your spouse have shared everything in one bank account, we may need to show that, hey, this money is all coming here, or maybe they're wasting money over here. You'd be surprised at how often we use screenshots, text messages, Facebook messages, things like that you may be able to get that we'll use those documents in court. So if you have, your spouse has left their iPad open on the table and you scroll through and you see these things, maybe messages from somebody they've been talking to you didn't know they were talking to, maybe funny business they've done with your money, you discover these things. You need to make sure when you're able to get screenshots, you save those, you get those in a safe place, because you better believe as soon as the other side knows you figure those things out, they're going to start deleting immediately. So you need to make sure you keep screenshots, text messages, financial records. All those are very valuable to us. Maybe you've been the only parent who's ever taken your child to the doctor. In all the years they've been alive, you've made sure they got their shots. You've made sure that they had a surgery they needed. You made sure that when they were sick, they got to the doctor, and you got the excuses for the school. Medical records can be important. Even all the records from the school that show you're the only parent who's ever signed that attendance sheet every day, or made sure you signed the little homework sheet every day. Those kind of things can be very helpful in your divorce. So documents are important. There are some clients that have told us before, I had all these things my lawyer never even showed the court. We want you to know, if it's very important to you for the court to see it, unless we just think it's totally irrelevant or hurts your case, we're going to give a chance for the judge to see and hear the evidence that you have, because that's the only way that you're going to be satisfied in the end, to know I had it all out there on the table and the judge heard my case and we didn't leave anything behind we could have used. Mediation is a really effective tool where we can find a way to reach an agreement between the two sides. Look, I know you and your spouse don't agree on everything, or you'd probably stay married to one another. But if you're going to be divorced, mediation can cut down on the time, the expense, and the stress many times of your divorce process. Mediation is simply this. You and your lawyer, they and their lawyer, go to a third lawyer who's going to play middleman between the two of y'all. You may worry, I don't want to be in the same room with that fool. I don't like them. I can't be married to them. I'm not going to sit down in the room and try to work out something. Most of the time in a mediation, you don't have to be in the same room. Typically, you're all going to show up to the mediator's office. You and your lawyer go into one room. They and their lawyer go to another room, and the mediator will go back and forth between the two rooms, making an offer here, taking it over here, making the offer to that side, and then negotiating back and forth throughout a half of a day, sometimes multiple days, depending on how complex your case is, to reach an agreement. Here's the best thing about it. If you go to a divorce trial, even if you both have the best lawyers in the state, you're going to put all your information out there, get all the testimony the judge needs to hear, but at the end of it, you lose all control. When your lawyer says, Judge, I want to call my first witness, control is out of your hands at that point, and control is in the judge's hands. The beautiful thing about a mediation is it gives you and your spouse control over what your final order is going to look like. You may have to give a little more than you wanted to in order to reach an agreement. Sometimes you walk out of there thinking, gosh, did either of us win today? But the great thing about it is you have control over what your order looks like. There's no waiting to find out what the judge is going to do. There's no stress or worry about, oh my gosh, did I make sure I said the right things in my testimony? No, with a mediation, you reach an agreement, both sides sign it, we submit it to the court, the judge signs off on it. Sometimes we mediate a case, and the mediator is not able to help both sides reach an agreement, and we end the day with no agreement, and then we still go to trial. And you may wonder, did I mess up? Did I give away too many things in that mediation since we didn't reach an agreement after all? Thankfully, no. Mediation is a confidential process, which means that all the mediators are going to report at the end of the day is either the case settled or the case didn't settle. They don't tell the judge, hey, this side offered this side offered that. And here's the great thing for you is maybe you were willing to give a lot to try to get the case settled. They rejected it, but when you go to trial, you don't want to give that much anymore. Those settlement negotiations are totally inadmissible in court, which means they can't go to the court and say, well, Judge, when we had mediated the case, she offered to give me the house, and now she's asking for the house. It's not admissible. It can't be used against you. So you should try mediation in your divorce and your custody case. It can cut down on the expense, it can cut down on the time involved, and it can give you control over what your divorce or custody order is going to look like. If you have questions about mediation, maybe before or after your case is filed, reach out to Word Family Law. We'd love to talk to you through the process and help you know if mediation is a good fit for you.